All right, looks good. Okay, good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of how to handle inherited property, including clearing title and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods. And typically we will be joined by Ms. Rachel Gutierrez, but she is actually out on vacation. So we're wishing her safe travels and a safe return home. But today's presentations are presented by our other partners with the Texas Legal Services Center. And we have today Ms. Uh, oh gosh, why am I just drawing a blank just now? Miss Lisa Nelson. Oh my gosh, I am so
Okay.
mentally. I think I might be on vacation or have cold fog or something like that. But included in the partnership as well, presenting today on behalf of the Harris Central Appraisal District, we have Miss Mabel Menifee, and on behalf of the Harris County Tax Assessor Collector's Office, we have Miss Shay Pinkowski. But also included in the partnership, we also have Lone Star Legal Aid, the Earl Carl Institute, and Houston Bar Association, and the Houston Volunteer Lawyers. And together we make up a month of service. And basically, what a month of service is the collaboration of all 9 organizations. We come together on a monthly basis and offer a variety of different workshops and resources and information to a lot of underserved communities that do not have access to a lot of information in regards to asset protection, asset building, community empowerment, and the maintaining of generational wealth. And we started this collaboration quite a few years ago in the effort to reach more people throughout the city of Houston, Harris County communities, as well as surrounding communities. But switching to a virtual platform has definitely allowed us the opportunity to reach even more people outside of the county, including surrounding counties, and in fact all over the state of Texas, as well as other states and sometimes even other countries. We broadcast our this virtual platform on Facebook and on our YouTube channel. So we want to thank you guys for joining us this afternoon. We hope that you are here to receive a lot of good information. This is kind of like part 2 of the of one of the asset protection workshops. Part 1 was basically about wills and estate planning and why do you need them. And this is kind of like the second part, like basically what happens after your loved one passes away when you're having to handle their inherited property. What happens with probate process? What happens when someone passes with deferred property taxes, heirship exemptions? So this is why we have included the tax assessor collector's office as well as the appraisal district in on this presentation, because they're one thing kind of leads into another, and we wanted to make sure that you guys got all the information from all resources so that you can see how one thing kind of impacts another. So again, there's going to be a lot of information that's going to be covered here today. So we want to welcome you guys to come back in case you have additional questions, or if you want to just hear it again, or if you want to invite, your neighbors, your loved one, other family members to come back each month to hear the information, we definitely welcome you to do that. So again, information that is presented here today is for educational purposes only. It is not to be considered any kind of legal advice, but we do encourage you to reach out to our legal service partners that do offer free civil legal services, civil legal assistance for those people that actually do qualify. And Ms. Lisa is going to go over some information about her organization as well and the services that they offer or that you all can take advantage of as well. So again, thank you guys for joining us this afternoon. We encourage you to answer any questions that it is that you may have. I want to remind everybody that this is a virtual platform and that we are streaming live as well as recording the session. So we want to try to protect your privacy as much as we possibly can. So we ask that you try to keep your questions general in nature, and feel free to type any questions in the chat, or reach out to the presenters directly with any personal detail information because we don't, or questions, because we don't want your personal information kind of getting out there for everybody to actually have access to. So please keep that in mind when you're asking your questions. You can feel free to unmute yourself or type your question into the chat. If you're joining on YouTube or on Facebook, please feel free to type your questions into the comment section and we will read those aloud at the end of the presentation as well to make sure that we get those covered for you. So without further ado, I think we're going to go ahead and get into our introductions and then we will get on into our presentation. So Ms. Mabel and Shay will have you go first and then Ms. Lisa will have you follow up last and that way you can go right on into your presentation. So Ms. Mabel?
Sure. Can you guys see me?
Yes, ma'am.
Okay. Good afternoon, everyone. Thanks for joining us today. My name is Mabel Menifee. I'm with the Harris Central Appraisal District, and I have the privilege of being a part of this particular presentation at the request of Miss Lisa Nelson, because one of the key areas or primary areas in terms of clearing title on inherited property often involves property taxes and contacting the appraisal district or also any additional taxes. And then we have such a somewhat of a complicated system here in Texas where property taxes do play an outsized role in funding of local services that a lot of people tend to overlook that piece. So we're going to talk a little bit about how property taxes and things that you need to do, particularly when you're trying to clear title on some property that you've inherited, the things that you need to remember and do. And I'm also joined today by the tax assessor collector, which is another arm of the property tax system. Ms. Shay Pentowski is going to join us on that, and she'll talk a little bit about their role in that. So thanks. I look forward to talking with you.
Awesome. Hello, everyone. My name is Shay. I'm with the Harris County Tax Office, Assessor Collector of N. Harris Bennett. As Ms. Mabel mentioned earlier, we are so excited to be here to share our knowledge and give any kind of a direction when it comes to the process of getting the taxes, specifically on my end, getting those taxes taken care of for any processes that you might be going through. I look forward to be able to share some knowledge and hopefully answer some questions. But if you have any questions, as Ms. Nia mentioned earlier, please try to keep them to a less personal nature for the time being, at least until we are able to contact you directly to make sure that none of your contact information or information gets let out into a public forum. But I'd be happy to answer any questions you guys have. So please feel free to write those into the chat box and I'll get back with you as soon as I am able to do so. But I look forward to be able to speak with you guys today. Thank you.
Okay, Ms. Lisa.
Good afternoon, everybody, and thank you so much for joining us today. My name is Lisa Nelson. I am a staff attorney with Texas Law Help. Actually, I'm a staff attorney with Texas Legal Services Center, and I'm on the Texas Law Help team. I'm going to show you our website real quick so that you have a better understanding of the services we offer. We provide statewide services, and this is our website, Texas Law Help. It includes pretty much every civil legal issue that you can think of. We do not provide assistance with criminal cases. That's not part of our grant. So we have topics so that you can educate yourself. And then we have the self-help tab, which has a way to get to the guides, the guided forms, and on Monday through Thursday from 10 to 2, we offer online legal assistance by licensed attorneys. And finally, the last tab is legal assistance, which has how to find legal aid and other attorneys in your area, events and clinics in your area, and some other information. Also, our site is in English, Spanish, and Vietnamese. I've been there for about 5 months, but I've been a part of the AMIS team for as long as it's been around. I started out in private practice, and then I was at the Earl Carl Institute for 4.5 years before joining Texas Legal Service Center. Okay. So today we talk about clearing title and other probate concerns. I asked Mabel and the tax assessor collector's office to join us as well, because a lot of what comes up with title issues are the issues of property tax. So I thought that'd be a great presentation for the three of us to partner on. So I'm going to first of all give an overview of probate. So this is where we are part 2 of how to do your estate planning documents. I'll explain how they're used. And then we'll talk about clearing title to inherited property. That's family property that's been in your family for maybe several generations. And every time I've helped somebody get clear title, I say, let's make sure no one in your family has to deal with this again. So I'll tell you how you can transfer property to your heirs. TLSC was founded in 1981, and we're a statewide nonprofit that provides legal advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas, and our work touches almost every aspect of civil law that impacts low-income Texans. Our mission is to ensure equal justice for all through education, empowerment, and representation. I will also put my website and email information in the chat. That's how you can reach me. Miss Nia also always knows where to find me. So let's start by talking about probate concerns. Probate is the process of basically wrapping up somebody's affairs after they pass away. So there's a lot of new vocabulary that you need to learn. Decedent is the person who passed away. Testate is someone who died with a legally valid will. Intestate is someone who died without a will. The testator is someone who has a will in place at the time of death. Testator is also used to define the person when they are signing their will. And a will is a legal document that states how the testator's property is to be distributed at death. Estate is your stuff, both your real and personal property that you own at the time of death. Probate is the process of winding up a person's affairs when there was a will. And administration, although it's still handled through the probate courts, is the legal process when someone passed without a will. The person who is in charge of the estate, the person who is in charge of wrapping up the decedent's affairs, is known as the executor. And the person who inherits is either known as an heir or a beneficiary. So a lot of misperceptions about estate planning and probate. Powers of attorney are fabulous tools. They are only valid while you're alive. Once somebody has passed away, power of attorney is void. I can't tell you how many times I've had people come to me and say, Mama didn't have a will, but I'm her power of attorney. That doesn't matter. That is only good during the lifetime. Spouses should have separate wills. Sometimes people have written, their handmade wills and written it up for both spouses. That is not legally valid. This is always a shock to married people. If you are married to someone who had a house before you got married, it may be considered separate property. A surviving spouse has a life estate to the home. It does not automatically become their home. Just because you're married doesn't mean that your home is community property. However, the surviving spouse can remain in the house until they pass away. They are responsible for maintenance and property taxes. And when you select someone to be an executor, if you have a will, or if you do not have a will and the family selects an administrator, they must be over 18. They cannot have a felony conviction, and they need to live within the state of Texas. One thing that is critical in Texas law, if your executor cannot find the original will, Texas law presumes that the will was revoked. You can probate a copy of a will, but it takes a lot more steps to get it approved by the judge. Texas does allow you to do your own will, and it's better to do your own will than have nothing. We have forms on our website that were approved by the Texas Supreme Court that you can use to prepare your own wills. You can also handwrite your will. However, I highly recommend that you have an attorney prepare your will, or at least take a look at it to make sure everything's okay. Amos has many opportunities throughout the year for will clinics. I know that they're planning one for September with where you would prepare your own documents, but then an attorney would review them, which is a great opportunity for everybody. Texas law does allow you to handwrite your wills. That's called a holographic will. It has to be wholly in your handwriting. It doesn't have to be cursive. It can be printed. It just needs to be in whatever your usual handwriting is, because you will have to have witnesses who say, she sent me cards every year. I saw her grocery list. That's definitely her handwriting. And be sure to keep your will in a safe place. If your will is lost, it's no good to anybody. A lot of people think my kids get along. I don't need to worry about having a will. That's not necessarily true. You never know how your family is going to act. People grieve very differently, and a lot of old hurts come to the surface as they fight with each other. I had a friend whose stepsister said, I don't care if I spend all of it on the lawyers. I don't want you to get a penny. So it's critical that you have a legally valid will. If you don't, the law determines who will inherit your property. If you cannot find a will, there is a process called administration. It will be either dependent or independent. Independent administration works when everybody gets along, none of the heirs are under the age of 18, and there isn't any fighting. I can tell you, but if one person decides to fight, the court will require that you have a dependent administration, and that is very expensive. If you have a dependent administration, the judge has to approve every single thing that you do. There is a process called a small estate affidavit. I'll go over it in details. It only works in extremely limited cases. You know, and in Texas, for 98% of all probate processes, you need to have an attorney. And it's really important to talk with an attorney because they know the best way to proceed. A lot of people file small estate affidavits and it doesn't work in their circumstances and they're out. I think it's close to $400 filing fee now. And they have to go and get an attorney and redo it all again. And you do not get a refund for filing the wrong thing by mistake. Probate assets are property that pass under a will. It could be your real estate, and more commonly, it's your personal property, your household items, furniture, your clothes, your jewelry, your car. Non-probate assets do not pass under a will. They pass in accordance with the terms of a contract. Common examples include life insurance policies, retirement plans, and payable on death accounts. One of the best tips that I can give everybody listening today is to make sure that all of your accounts have payable on death beneficiaries. If you have payable on death beneficiaries on all your financial accounts and a transfer on death deed for your home, your family might not need to probate a will. Just make sure, every 5 to 10 years, you need to check with all of your accounts. Make sure they have those beneficiaries. Make sure the names are correct. People get married, people get divorced. I had a sad situation where someone used his friend's nickname instead of her legal name on his transfer on his payable on death account. And she ended up having to spend a few $1,000s going to court to get an account that wasn't worth much more than that. Okay, small estate affidavits in most counties in Texas. In Harris and Fort Bend County, you don't have to have an attorney if you use a small estate affidavit. However, they can only be used to transfer real property if you meet the following conditions. It has to be inherited by a surviving spouse or minor child. That's a child under 18. An adult child cannot inherit a house through a small estate affidavit. Every heir has to sign the small estate affidavit along with 2 disinterested witnesses. Disinterested witnesses are people who knew the person well, knew their family history, but aren't legally entitled to any part of the estate. You cannot use a small estate affidavit if the person had a will. And you cannot use a small estate affidavit if the value of the assets is greater than the debts of estate. So for example, if you have $20,000 in assets, but you've got $40,000 in unpaid debt, the court would not approve the small estate affidavit. Also, the estate excluding the homestead has to be less than 75,000. Probate procedures, a lot of people think that probate sounds like a scary term and everybody thinks they need to have a trust to avoid probate. If you have a will that was done correctly, probate is relatively simple. Your attorney will file an application to probate or application for independent administration. After 10 days, the attorney can schedule the hearing. This does not mean that you will get to go to court 10 days after your attorney files the application. Harris County just opened its 5th probate court and it is still extremely backlogged. You are lucky if you get a hearing in 6 months. If a judge grants the application for administration, the personal representative receives letters of administration. If it is a will, the executor receives letters testamentary. If the person who is the representative for the estate is responsible for gathering all the assets and opening a bank account for the estate, you do have to get a tax ID number, which is like a business social security number for the estate before the bank will let you open that account. The attorney notifies creditors, and then the attorney and the personal representative prepare and file an inventory, which is a list of property that the person owned as of the date of death. Now, don't ever think that anyone is responsible for your debt. The debt is only paid out of what the estate has. Your executor, your administrator, your children, they're not responsible for your debts at all. The one thing that won't go away is IRS taxes. Anything else, if you don't have the funds to pay for it, they're not able to collect it. And that would be if the estate in the estate account doesn't have the funds for it. Clearing, when I was at Earl Carl, this was the biggest part of our work. So many people live in family homes and don't realize that they don't have clear title. If you live in a family home and you don't have clear title, you don't qualify for local, state, or federal assistance if there's a natural disaster. So a lot of times we have a hurricane, we have a winter storm, somebody applies for FEMA help or for state help. They go to apply and you can't get the aid if you don't have clear title to the house. So we have to backtrack and clean everything up. And also, you can't get property tax exemptions or deferrals if you're not the owner of record. A clear title means that no one else has a financial interest in your property. It also means that there's no question of ownership and that the ownership history of a property can be easily traced. When property is not legally transferred or deeded to the subsequent owner, it becomes cloudy. Cloudy titles happen when somebody dies without a will or the family doesn't manage the estate. So for example, we had people who sometimes would be a great-great-grandparent purchased that home and nobody knew that they needed to transfer it because it was always the family home. And then something comes up, they get a storm and they have a lot of damage and they apply for assistance and they find out that that property is still in the name of that ancestor. That would be a cloudy title. To make sure you have a clear title going in the future is you file a transfer on death deed. It's the easiest and least expensive way to transfer real estate to someone after you die. A will is a perfectly valid way to transfer property also. Filing a transfer on death deeds are the easiest and least expensive way to do it. Besides the disaster recovery assistance and property tax relief, if you don't have clear title, you can't apply for home improvements or other types of real property loans. So many people think that they have a will, everything's fine because they had a will. No, you have to go through the probate process. If you don't probate your loved one's estate, you may not have clear title on any property, and you most likely will not be able to access any financial accounts. There's a few ways to clear title through the courts. If the homeowner died within 4 years, you need to file an application for administration or to probate their will. If it's been more than 4 years, and they had a will, you can file an application to probate as muniment of title. That tells the court the only thing we need to do is clear title to the property. The rest of their affairs have been settled. And finally, there's also adverse possession if you meet the requirements for that legally. So if your loved one passes away within 4 years, this is the easiest way to do this. You probate their will or file an application for administration. If it's a will, the judge determines whether the decedent left a will compliant with Texas law. If the decedent did not leave a will, you can file an application for administration. If it has been more than 4 years since the person passed away, you can file an application for probate as muniment of title. There has to be a legally valid will, and all the heirs must agree to probate the will. After the judge admits the will to probate, you file a certified copy of the signed order and the will, and the person will have clear title. The person named in the will will have clear title to the house. Everybody's heard a little bit about adverse possession. It's a legal principle that allows a person to obtain legal ownership of a property based on continuous occupation without permission for a specified length of time. There's several different laws that cover this. Usually you have to be in the home at least. You kept the property up. If, a lot of times what happens is somebody has a lot next door to them and then they decide to use it for gardening or for the kids to play. They clean up the property, they fence it off. Everybody knows that they've been using that property for the correct period of time. One thing critical with adverse possession, you cannot use that process if you have permission to live at that property. So I had someone come to me who everyone in the family agreed that she could live at the property as long as she had, as long as she paid the taxes and kept the property up. They would not agree to transfer the home to her. She could not use adverse possession because she had permission to live at that house. The least expensive and easiest way to clear title is an affidavit of heirship. It's a legal document that gives property to the heirs of a person who died. It may be needed if the homeowner did not have a will or the will wasn't probated within 4 years. This is something that you absolutely can do on your own. At our website, texaslawhelp.org, we have a guided form that will walk you through the steps. It has to be signed and notarized by 2 people who knew the deceased person and their family history. It cannot be the child. It cannot be the surviving spouse. It has to be someone who isn't legally entitled to that house. So it can be aunts, uncles, cousins, neighbors that you've known since the family's been in the neighborhood. It's critical that you have the full legal description, which is found on the deed. You can get a copy of the deed at the county clerk's office. I think it's $1 per page, and they can help you look for it. There's also some sites online. If you search for Texas deed search, there are a couple sites that you can search for your deed online, and I believe it's $1 a page. I tried it out just as an example, just to see what it was like, and it was very simple for me to find my deed. And the affidavit of heirship has to be filed in the county where the property is located, at the county clerk's office. There is a filing fee that varies by county. In Harris County, you're looking at $30 and up. It's $26 for the first page and $4 for each additional page. Fort Bend County, I believe, is slightly less. And but they're all more or less the same filing, more or less the same. The affidavit, oops. I harp about the small estate affidavit because I have heard about this from a lot of people I know who work in the courts. So many people will go to the clerk's office and say, my loved one passed away. She didn't have a will. What do I need to do to resolve her affairs? And the clerk, who is not an attorney, will say, oh, if you don't have an attorney, you should file a small estate affidavit. No, that doesn't work. It gets really frustrating because people are out, like I said, $400. You don't get your money back and you have to go back and file all over again. So a small estate affidavit is only available when there is a surviving spouse or surviving minor child. You can also use small estate affidavits for other things. If a loved one only had a bank account and you want to transfer the bank account to the heirs, you can use a small estate affidavit. And small estate affidavits are a lot less expensive than the full probate. So if you can get away with it, it can be helpful, but you need to be very careful that you're using it correctly. Affidavit of heirship is the best way to transfer a home to adult children or other people who would inherit it, nieces, nephews. You can use an affidavit of heirship to transfer real property to a surviving spouse if there are no other estate assets. As I said, every time I've helped somebody with clear title, I say, let's please make sure your family doesn't go through this in the future. The best thing you can do is a transfer on death deed. It's a simple, inexpensive way for you to transfer a home or real estate to someone else upon their death. It does not affect the owner's rights at all. You own that house 100% while you are alive. You can sell it. You can use the property to get a loan. You still are entitled to those property tax exemptions and deferrals. The beneficiary has absolutely no rights until the owner passes away. The owner can also change a beneficiary or cancel the transfer on death deed entirely. And just like the affidavit of heirship, the transfer on death deed has to be filed in the county where the real property is located. You don't want to take the transfer on death deed and keep it in a safe place where your other important papers are. That's no good. It has to be filed. And like the affidavit of heirship, there's a filing fee roughly between $30 and $50. At our website that I showed you before I started, we have a transfer on death toolkit that shows you in detail how to fill this out. Again, you do not need an attorney for this. You absolutely need the full legal description. If you use the legal description from your property tax bill, the deed will be incomplete and it will probably be void. The other thing that is critical about the transfer on death deed is it protects your property from Medicaid estate recovery. Medicaid estate recovery is a program that if someone uses Medicaid to pay their, most commonly to pay for their nursing home bills, after that person and their surviving spouse pass away, Medicaid can seek reimbursement through the probate of the estate. Medicaid can only seek reimbursement through probate. They cannot go after it if you use a transfer on death deed to transfer your properties for your heirs. So this is something everyone should be doing. I like to give all the resources that you have in our area. Our website is statewide. There's Earl Carl Property Preservation at Texas Southern University. Lone Star Legal Aid is a large legal aid organization that serves the greater Houston area and beyond. There's Legal Line through the Houston Bar Association, which is a fabulous program. You get a free 20-minute consultation with an attorney. They cannot take your case, but they are allowed to give you legal advice and they can let you know what to do going forward. So they can help you come up with a plan. And the Houston Lawyer Referral Service is a great place when you do know that you need an attorney. They have a list of people that do not charge high fees. And they also have, if an attorney takes your case through this program, they have to give you a 30-minute consultation for $20. I tell people to use it all the time. Sometimes all you need is that 30-minute consult. Thank you very much for your time. I'm going to pass it over to my tax friends, starting with Mabel at the tax assessor's office. Have a good afternoon.
Thank you, Lisa. All right, this should be easy since I already have it up. Good afternoon, everyone. Again, my name is Mabel Menifee, and I'm with the Harris Central Appraisal District. And today, because property tax issues often dovetail with getting clear title on inherited property, we're gonna talk a little bit about, property taxes.
You don't
And
have your slideshow up yet.
there we go. Thank you, Lisa.
You're welcome.
That slideshow, okay, and. Okay, that should look, that looks good,
I don't see it.
I don't see it yet.
okay. How about now?
No,
No.
Oh, gracious. Now,
no, I think you need to click share. It's like a green button.
okay,
You have to start with share that's down at the bottom,
I-
almost in the middle. It's a green button.
thought I had. Apologies, everyone, this. I think my setup is different from everyone else's, and it seems to happen. Let's see.
If you go to the Zoom window,
So I am,
oh, to the bottom.
okay, we're back to. Okay. Hold on, I'm gonna go back to the main one, my.
I think yes. Now we
Okay.
see this light.
For some reason, I'm supposed to hit share twice. I do not know why. Apologies for the interruption, everyone. And
You have a complicated system.
I apparently do. Okay, now that good? Is that good?
Yes.
All right. Okay. Good afternoon again, everyone. Sorry for the interruption, but today,
I think it's showing the one with the
I can't hear. Are we good? Did that just move?
yeah, I think it's on the presenters version because I'm seeing the next slide.
Oh, okay.
I don't know if you wanted to fix that or not, but I could see it. It's
I
just
don't
smaller.
care. That's fine.
You
That
can
was
do,
so-
I think it's display settings and then swap screens.
all
There
right.
you go.
Yeah.
You got
Good.
it.
Okay.
Yes.
All right, did all
Here we
that once, but it didn't work. So here we are, good, ready to go. So we're gonna go over today some of the things that you may need to know in terms of what you need to do as far as inheriting property and what and how taxes play a role in that. And I'm starting out because I'm with the appraisal district, which is the first piece of that, or the first side of that property tax coin that we like to refer to being the valuation piece and administration of exemptions that HCAD does, and then there's the assessment and collection piece that Shay's gonna talk to you about later that rolls over to the job of the tax assessor collectors. So just quickly, what is, a couple of things I'm gonna go over. I'm sure most of you, many of you already know out there, but just for the sake of us establishing context, we all know that, Texas does not have a state income tax. That's why a lot of people like to move here. But what it also is a reflection of is that property taxes tend to pay a bit more of an outsized role in funding the local services that taxes pay for, like your schools and your police department, local hospitals, road maintenance, community colleges, that sort of thing. So it's important to also remember that property tax laws, as far as the state of Texas are concerned, they originate in Austin with the Texas State Legislature, and embedded in the state constitution, there's the Texas Property Tax Code, which is a book about so thick that we're responsible for administering, which is why we have a number of departments that do various types of work on that. And so the main responsibilities of an appraisal district, and there's one in each county in Texas, is that they appraise all the property in that county, whether it's residential, such as homes, whether it's commercial, agricultural, can be industrial, and then business personal as well. And the state law requires them to do so at 100% of market value each year, and that's each year as of January the 1st. January the 1st is that mostly magical number in terms of your property, whatever your value is that the appraisal district assigns each year is going to be based on the condition of that property as it was as of January the 1st. That means in terms of ownership, in terms of the condition of the property, etc. The other thing that we do is also we administer exemptions, and we're going to talk about exemptions because that's that's an important piece of the property tax code to know. It can save you money, and it also is important when understanding how taxes are completed on a residence. So the other thing that we do, and we're getting close to it right now, is each year in the late summer, we certify appraisal rolls. And what does that mean? We basically have to say to all the taxing jurisdictions, that's like the city, the county, your MUD district, that this is the roll, this is the amount of the roll for this year from taxes. And then that allows them to go ahead and set their property tax rates so that then those bills can be generated so that they can go out to you usually in late October, early November, and are due by the end of January each year. As I mentioned before, we are required to be at 100% of market value. The oversight as such in terms of, okay, so who's in charge of the appraisal districts or who oversees those? I mentioned that Texas state legislature is who oversees in terms of passing the laws and the property tax code. And the kind of oversight agency for us is going to be the Texas State Comptroller. They conduct something called a market value study each year to make sure that CADs are doing what they're supposed to do within the counties. Of course, the value is always going to be derived on sales. You all know that in terms of the value of the property in question. And just a little fun fact for HCAD is that in Harris County, there are over 1.9 million parcels of property that have to be valued each year. And believe it or not, there are more than 500 taxing jurisdictions. You may only pay taxes to 5 or 6, 4 or 5, but there are over 500, depending on where you live, that you pay to. Important dates, I mentioned January the 1st, also May 15th, for those of you who receive valuation notices for a certain property and want to disagree with that value, you can file that protest by May 15th, the statutory deadline. Sometimes it's later if your valuation notice goes out later, but May 15th is an important date to remember for that. And then as we talked, the tax bills are going to be mailed out usually in October or November, and on February the 1st, if they have not been paid, they become delinquent. This is if you own a home or you are in the process of being the executor or taking care of property of a deceased, and it happens to be in March or April. This is the appraisal notice that they generally receive from HCAD, determining that provides the appraisal value for that year. It's important to remember when you see this, that this is a copy of a sample of one from 2024. So it's important to remember too that you're going to get two values on that. One is going to be the appraised value, the other is the market value. Always remember that is the appraised value upon which taxes are calculated, not the market value. The market value is, however, the value that HCAD establishes each year, but it is the appraised value that taxes are paid on. And why can those be different? How can those be different? Oftentimes it is because of the exemptions that are on the property. So that's one of the reasons we want to talk about that. And as I mentioned, just to kind of go over that again because it's important for people to understand. The appraised value is the value or the number that's going to be used in calculating your tax bills. It could be the same as market value, particularly if you don't have any exemptions. If you have exemptions, it's going to be lower for a number of reasons, primarily because each year, anytime there is a rise in value, your property can, the appraisal appraised value can never go up more than 10% in each year. So that's important for people who particularly are living in areas and in Texas in general. As we've seen over the last 3 or 4 years, property values can rise exponentially in some areas. So having that 10% appraisal cap, which is part of an exemption, protects you from those rapidly rising values. Market value, again, is what HCAD's role is in the property tax process. It's what HCAD establishes, and that's the value at which a property would sell to for a willing buyer out on the open market. Also important to remember that protests are going to always be based on that market value. And just kind of quickly wanted to go over what you might see with in terms of your options for protesting. And if you are inheriting a property, you can certainly file for that. You can certainly protest a value. There are a number of ways to do so. You can do it online. You can come out, you can speak with an HCAD appraiser in what we call an informal hearing, or you can appear before what's called the appraisal review board for a formal hearing. And these are people who are who've been appointed to hear your protest. They are property owners in Harris County. They've been selected to be on the appraisal review board. Excuse me. And then, of course, there are also other legal options that you can pursue in terms of arbitration, various methods there as well. Now let's talk a little bit about exemptions, because is something that's important to understand when you are dealing with selling someone's estate or when you are taking ownership of inherited property. So they are administered by HCAD, and what exemptions do is they exempt a portion of that property's value from taxation on a person's primary residence. That's the residence that they live in, own, and live in. And again, those exemptions are used by taxing authorities to calculate the value. So it's important to understand how how a person becomes eligible for these exemptions, because a lot of times what happens when someone moves into a property that a grandparent or parent and uncle once owned, when they move in, when that ownership changes, those exemptions go away and they are not eligible for that person's exemptions. The exemptions, I like to say, always go with the individual, not with the property. So it's very important to understand whether or not you're eligible for those and what has to be done if you are not. So basically, exemptions reduce that appraised value before the tax rates are applied. It's kind of like a discount on your property taxes. They exclude part of your property from taxation. So the most common one's going to be the general resident homestead. There is another one. Once a person has that general resident homestead and they turn 65, there is an over 65 exemption, which is on top of the general resident homestead exemption. Also, spouses who are over 55, when the other spouse that may have been over 65 and was receiving the over 65 exemption for that property, as long as the surviving spouse is at least 55 years of age, he or she will be able to continue that exemption with no interruption. There's also something called the disability exemption. Obviously, that's self-explanatory for folks who are disabled. It's very similar to the over 65 exemption, pretty much almost the same for those. Then there's one called the disabled veterans exemption. based on your disability percentage. Those are available for veterans, as well as other service-related exemptions, which you can find out on our website. The general resident homestead exemption, which you can apply for at HCAD, is just you have to own and occupy. The person had to own and occupy it as their primary residence, as I mentioned before. Some of the benefits that they get for that is $100,000 school tax exemption, and that's according to state law. Everyone in Texas who applies for it, receives it, gets that. And that basically means that, say, if your house is worth $300,000, you will only be taxed on the first $200,000 for that state school tax exemption, and that's for school taxes. Other exemptions, depending on where you live, are going to be offered by other jurisdictions. I think Shay's going to talk a little bit about some of the exemptions offered by the county, as well as the city, but it just kind of depends on where you live in the Harris County, in Harris County. The over 65 exemption, that is on top of the general and disability. As I mentioned, those two are pretty much the same. The over 65 exemption is something that you qualify, obviously, when you're over 65. The disability exemption, you are able to qualify for the year that you become eligible also, because if you receive disability through the Social Security Act, or maybe you aren't on Social Security and you're disabled, they can also provide that through a physician's statement. Benefits for that one is that your school tax ceiling, the school taxes are frozen at the amount that they were the year you turned 65. They'll never go over that. They can go under that if for some reason the property value falls, but they will never go over that unless you do something to substantially increase the value of the property, such as add square footage to the home, or build a swimming pool, or put a tennis court in the backyard. Then, of course, your value can be recalculated before that benefit becomes set again. Again, some of the other, there may be other exemptions under the over 65 and disability exemption that are offered where you live. That's something you can usually tell by looking at the tax bill. The over 55, I explained it. It allows the surviving spouse who is at least 55, if the household is already receiving the over 65 exemption, it allows that spouse to continue with it. And then, of course, receive all of the benefits that we described for the over 65 exemption. Another important one to remember, and this is something that a lot of folks may not know about, but it allows when there are multiple heirs, and say there is one, they may be living in the property, or there may only be one heir living in the property. And of course, in that case, that particular heir is maintaining the property, taking care of it, paying all the bills, paying the taxes, and the other heirs may be living in their own homestead exempted homes elsewhere. This particular section will allow that person to receive the 100% of those exemptions that I just talked about, because previously, because they did not have full ownership, they may have only been able to get a percentage of that homestead exemption. Say if there were 4 heirs, they may have only been able to get 25% of it. This particular section, if that they can complete and provide the particular information that we would need, would allow that one person to get the full 100% ownership. I'm sorry, the full 100% of the exemption without affecting the ownership rights of the other heirs. So that's kind of an important, critical thing to remember. It helps keep the family. Again, it's something that will help keep property in the family for a continued period of time, as well as just offer some relief to that particular person. So immediate resident homestead exemption, I'm not sure if this applies to anyone listening today, but it is something that the legislature put into place a couple of years ago that allows folks who are moving into, say, a new home, a brand new built home, or one that previously did not have an exemption on it, the previous owner didn't have an exemption. It allows them to go ahead and get that homestead exemption rather than waiting until January the 1st of a new year before they would even qualify. This immediate resident homestead exemption allows them to get that exemption right away as soon as they move into the house on that prorated basis. So if they were to move into the house in April, then and file for this exemption, then they would be eligible to receive it for 8 months of that year. It's important to remember that this only applies to homes where the previous owner did not have exemptions on the property. If the previous owner did, you would still benefit from whatever exemptions they already had in place for the rest of that year. Also important to remember that if you're gonna file for this, you must file for it before the first anniversary of when you moved into the home. So again, let's look at those exemptions and how do you apply for them? So you can mail the paper form, online form, through mobile app. And once you've applied, we are required to, within 90 days now, notify you if those exemptions have been approved. And we also have how to request. Not sure what happened there, but how to request or remove a homestead. There's a video. I'm not sure what happened there because I made some changes and something happened there. But anyway, there is a video as well out on our website that you can take a look at if you are not sure of how to file for those exemptions. And this video will walk you through step by step, as well as other helpful videos out there that can help you understand other parts of the property tax process. I did want to, and you can actually follow these instructions, follow that video as you fill out the form for exemption request. I did want to mention too, for some of you that are maybe listening to this and realizing that, oh, I may be in a situation where I've moved into a home which I may no longer be eligible for the exemptions that the previous person had. You can also go out on our website and get the form that's called a request to remove homestead exemptions. So on our website, www.hcad.org, under forms, we may require some documentation such as a death certificate, a probate materials, or something just to prove your eligibility for that. Another way and this kind of serves as a reminder for folks that are maybe moving into a new place that was previously owned by someone and they are not eligible for those exemptions. It's something that we typically mail in December. It's just kind of your exemptions confirmation card. If you own and occupy a home, you've probably seen these each year. They come in about January or December. Typically, if nothing has changed, you just kind of throw it in the drawer and leave it there if they're fine. But if something has changed, this is your opportunity. This is your reminder to notify HCAD that it has changed, that there may be exemptions on the property that the new person is no longer eligible for. And typically it's important to do this because state law requires that if you have been living in a home and not paying and benefiting from exemptions that you were not eligible for, then it can go back as far as 5 years to collect anything that you may still owe. So it's important to kind of make sure you get that taken care of. Also, if you missed out on some exemptions that you should have had, we can go back 2 years plus the current year to correct that. So it can benefit you either way. And then one thing I want to also just add before I move on to the next and to the last slide is that there is quite a bit of confusion sometimes out in the community about the difference between a over 65 exemption and something called a tax deferral, which you're eligible for once you get that over 65 exemption. The difference between the two is that the over 65 exemption is something that you're granted as a discount. It's not anything that you have to pay back. It's something that lowers your tax liability and as long as you're eligible for it and living in that property, there is nothing you have to do. There's nothing nothing in law that forces you to pay it back. That is something called a tax deferral, and that's a different process. We're going to talk a little bit about that. Shay's going to mention a little bit about that, but I wanted to also highlight that because I talk to so many people who get those two confused and say, I don't want that exemption because my kids will have to pay it back. They don't pay back your over 65 exemption. That is something that just goes on your property. You'll hear a little bit more about the tax deferral, which is something that you can opt to as far as postponing your taxes, all of your taxes, but that does in fact become due in 180 days after the ownership change, usually because of the person has either sold the property or they are deceased. And then that is important it's very important to make that distinction among our property owners. This is what our website looks like. I mentioned that you can go up here. You'll see that second blue line there says forms. You can click on that and drop down and find just about all of the forms that we have, including the request for application for your exemptions, as well as a request to remove them. Also, we've got some helpful videos on various subjects there under help. And then of course the property search. For any of you out there that may have been listening to me and wondering, well, do I have my exemptions? What kind of exemptions do we have on the property? You can always go out on the property search, type in the address, account number, and it will show in the left-hand column what type of exemptions are on that property. One thing I need to add is that it's going to say residential homestead, which is the basic exemption that you will get. If you also have an over 65 or disability, it's not going to say that because we're not allowed to kind of give out that type of personal information on a public website, but it will say multiple. And that means whatever the other exemption you have applied for are also on there. So please keep that in mind. And then finally, one last thing I want to mention because of all the storms and things, and there may be people out there listening to this, and that is the temporary exemption for property which has been damaged by disaster. And boy, have we had our share of them over these last 3 months. The temporary disaster exemption allows people who have reached a threshold of at least 15% of their 15% physical damage to their property. And that's going to be based on their values, of course. They are eligible for something called a temporary disaster exemption, which will give them some relief from paying the full taxes for the year because their property is indeed not worth what it was on January the 1st. It has to be physical damage, and it is to the property. And the application is on our website, and you have until early October, I believe it's October the 12th, to apply for that. And basically, you can apply for it on our website. We do ask for a little, and the type of information that you're going to need for that basically will be your insurance quotes, probably if you've got your FEMA papers and photos about the damage are some of the primary things you'll need. But again, you may be affected by this, or you may have neighbors or relatives that were. So if you can get a chance, please spread the word that they'll have until early October to file for this. And that is all I have. Here's our contact information. We're out on the Northwest Freeway. You can call us, general phone number. We have an online help source that you can go to and contact us that way as well. I just want to say thanks so much for listening. I hope we've been helpful in helpful with uh, painting that picture of some of the issues that you deal with as far as property taxes when it comes to clearing title on property. And now I'm going to turn it over to Shay Pankowski with the Harris County Tax Assessor Collector's Office.
Awesome. Thank you so much, Mabel. Appreciate you. Alrighty, so let me go ahead and get my screen up here. All right, hopefully everyone can see that properly and my voice is coming through clearly. If I need to speak up, please let me know. But hello, my name is Shay Pankowski. I'm here with the office of Ann Harris Bennett, who is our Harris County Tax Assessor Collector, and we collect for property taxes for the County of Harris and all of the jurisdictions that are collected by our Assessor Collector, Ann Harris Bennett. Just a quick overview, a lot of the information that I'm going to provide is also information that is pertaining to Miss Mabel's office with the Harris Central Appraisal District, and that is because we go hand in hand when it comes to our processes and where we get our information. All of that comes from the appraisal district, and we work pretty closely together as groups. So if I repeat myself, I apologize, but let's go ahead and dive in here. So just as a general overview, for property taxes, we maintain approximately 1.7 million tax accounts, and that is just for those that are collected for by the Office of Ann Harris Bennett, so our Harris County taxes, City of Houston, that type of thing. We collect more than $8 billion in property taxes each year, and we do disperse to more than 80 taxing jurisdictions. So like I mentioned before, Harris County, Houston ISD, our City of Houston, and Harris County Flood Control District, just to name a few. There are 80 jurisdictions that we collect for. So a lot of times you'll see our bill and it's a very great number. And part of that is because of the fact that we collect for so many jurisdictions. And the more jurisdictions we collect for, the more apply to you, more than likely. So if you see a big bill from us, it's because of what we collect for. Speaking of calculating your tax bill, we have a little visual representation here for calculating taxes. And this is a pretty rough explanation for it, but essentially the taxable value of your property multiplied by the tax rate, which is determined by each of the jurisdictions separately, is equal to your tax bill. This is just the very bare bones of it, but that is how the taxes are calculated. Your exemptions would be reduced from the taxable value. So if you had an exemption present on your property, it would be your taxable value minus your exemptions and then multiplied by your tax rate. And that's how we determine your bill. So there have been recent top property taxes changed. So Harris County increased the over 65 and disabled exemption from 250,000 to 275,000, and then in 2024 we anticipate that to increase more to 320,000 for exemptions. City of Houston increased their over 65 exemption as well, and that increased from 160 to 260. The general homestead exemption for your school, meaning your ISD, Houston ISD, Katy ISD, any of the ISDs that you pay for depending on where you live, increased from 25,000 to 100,000, which was a pretty big jump for a lot of folks. People saw a very reduced bill because of that on their school. Homestead exemptions are eligible for proration now, meaning that as opposed to having to wait for the first full year in which you live in your property, you're now able to apply for your general homestead exemption starting from the month and date in which you began living in that property. You don't have to wait for the full first year anymore, which is a really great help for a lot of folks as well. This is some of the legislature that was passed this past November, and that is something in reference to school property taxes. A lot of you saw that exemption amount for your homestead increase from 40,000 to 100,000, and a lot of people are really excited about it. That is something that we voted on as a group in the state. So that was passed this past year in November. We were able to vote on a limit for property appraisal on non-residential properties under $5 million. This would be applicable to, smaller businesses with less than $5 million for the value. We do have a new system in place for restructuring the school finance system. And in order to kind of break this down a little bit, um, we reconstructed the values on which the taxes were paid for your school. So it also increased the school cap, which in conclusion made it so that your taxes would be lowered due to this tax cap being increased. This is something that a lot of you will be familiar with just based off of what your tax bill would look like. Most of them look similar. This is ours specifically. The tax bill would be this page over here on the left, and the bottom portion is something that you'd be familiar with sending in the mail with a check or coming into an office with it present so that you can make your payment in one of our offices. It includes your ownership information along with the payment amount that you'd be making your payment for and the information for who to make the checks payable to. Occasionally, there'll be a message to the taxpayer on that little slip of a form as well, and that is mostly letting you know that if you're 65 ages of the age of 65 years or older, you're able to submit this document in for your homestead, and you may be able to have a postponement for your taxes, meaning the deferral that Ms. Mabel touched on earlier. Just as another visual representation of homestead exemptions and how they can affect you, for the property to be $325,000 as the value, without a homestead exemption, your bill for the property on our end would be approximately 7,153. And this is, as I mentioned before, this is an example. So um, with a homestead exemption, you would save about $1,830 on a bill of that size, meaning that instead of paying the full 7,153, you would pay a tax bill of 5,323. And then when you include the over 65 exemption or disabled exemption on top of the homestead, it does reduce it drastically. So you can see the difference between what your taxes would be without any exemptions, with a homestead, and then with an over 65 or disabled exemption. The tax bill would turn out to be about $2,327. And you can see how big of a difference that makes just between having an exemption and not applying for it. So we always encourage you, if you believe that you are eligible for that, to apply for it and get that taken care of. It's not something you want to just leave sitting out for no reason. Tax limitations are commonly referred to as a tax ceiling or a tax freeze, and usually this is in reference to your school, meaning that there is a limitation of how much you would pay for your schooling that starts the year in which you turn over 65 or are applied and applicable to the disabled exemptions. And this also helps to reduce your tax bill because while your property taxes do increase, the value of your property increases, you do have that limitation of how much you would be collected on for your school. And this does not apply to all of your jurisdictions, but this does apply to your school jurisdiction. Tax deferral. We will always recommend that if you are over 65, you have the over 65 exemption and a homestead, or you have the homestead exemption and the disability exemption, that you apply for a tax deferral. Now, the reason that we recommend it so highly is because while you may not always need to defer your taxes, meaning you might still be able to make your payments for property taxes, by the end of January every year, and it's not something that you're required to have, and you're not physically needing it. It is something that we recommend just on the off chance that the unspeakable happens or something occurs to where you are not able to make that payment, or even if it just slips your mind for a little bit and you come back and you realize that you hadn't paid your property taxes. This tax deferral saves you from litigation. It saves you from postponement of taxes and preventing foreclosure. You would only pay a 5% interest per year, meaning that it ends up being about 2 point something percent every month of penalty and interest, as opposed to the full scope of penalty and interest that you would get collected on without the tax deferral. It delays your property taxes, meaning that you have that additional time to pay with that reduced penalty and interest. Um, those taxes are still due, meaning that you still are required to pay those taxes. So whenever that property is no longer under your ownership, whether it be because you sell the property or whether you unfortunately pass away, it is something to make note of that those taxes are still due. And as Ms. Mabel mentioned earlier, you do have 181 days to make that full payment of the deferred taxes from the date of that property no longer being yours to be paid without penalty and interest, or at the penalty and interest that it is with that 5%, as opposed to with full scope penalty and interest. That is something you can apply with through the Harris Central Appraisal District. They would take your application for the tax deferral. Um, and again, this is for your homesteaded property as an over 65 or disabled homeowner or disabled veteran. Just a little note there that is added in yellow. When you are considering placing a tax deferral on your property, we do recommend that you speak to a mortgage company if you are still making payments on your property with a mortgage, just due to the fact that not all mortgage companies will allow for you to defer taxes, just on the simple base of them not wanting to have that information deferred. And that is something that you would want to speak to your mortgage company or your mortgage lender in regards to make sure that that is something applicable to you that you could do for your property. Let's see. We also offer flexible payment plans that begin as early as February 1st. And the reason is February 1st is due to the fact that most property taxes are due by the end of January, unless extenuating circumstances occur. This allows you to avoid collection efforts whenever you create a payment agreement with us. It does save you from litigation with our attorneys in order to continue to make your payments and just notify us that you are intending to make those payments. Every July, we are obligated to submit our unpaid taxes to our attorneys, and those attorneys therefore add fees once they've received the tax accounts are still due. So, in order to avoid foreclosure actions, additional payments in the form of attorney's fees or additional litigation, if you know that you're not going to be able to pay your property taxes timely by that January 31st due date, we do recommend giving us a call in February in order to go ahead and get your payment plan started for you. In addition to all the other options that we've listed before, for our over 65 disabled owner and disabled veterans, along with their surviving spouses, we have something called a quarterly payment plan available. Now, this quarterly payment plan is something that we offer as Harris County. So there is no interest to be paid on the property taxes if these quarterly payments are made timely. That first payment would be due at the end of January, as your normal payments would be, at a quarter of what the total amount is, followed by a due date in March, May, and July. So as long as those 4 payments are made in full and timely, there's no interest or penalties to be paid. And this is applicable towards your property taxes due for that year. And your account does have to have that over 65 and residential homestead exemption in order for this quarterly payment to be applicable. So make sure that you have your exemptions in order with the appraisal district in order to be able to take advantage of these payment plans for quarterly. All right, this is a little bit more information on our payment plans. And the reason that we have this up is to explain the differences between a homesteaded plan and a non-homesteaded property plan. Homesteaded properties are applicable to those properties that have that homestead exemption. We can offer them anywhere from 12 to 36 months, so 12, 24, 36 months. We have a 1% interest per month plus the initial penalty month, which is going to be dependent on when you create your payment plan. This is in regards to current and prior years of taxes, meaning that if you still have taxes due from 2022 along with 2023, you're able to create that payment plan for both. And the due dates for both of these are going to be due at the end of each month, from the date that payment plan begins. homesteaded properties are allowed with, the regular payment plan, which includes the non-residence, business and commercial, and personal property. The time lengths that we're able to offer are the same, so it's still the 12, 24, 36 months. And the penalty and interest does not change. So what this property payment plan assists you with is avoiding further litigation, court costs, and foreclosures of property. And again, this can be applied towards current and prior years of taxes, and the payments would be due at the end of each month. We have our payment options listed here. So when making a payment to our office, we can accept payments online through our website. We can take payments by mail. So if you'd prefer to send in a check or a money order to us by mail, we do offer payment by telephone through our automated system. And of course, you are able to come into any of our branch offices to make a payment. We do have 16 available, so hopefully there's one that is very near to you. But you can always look those up on our website to see all of the addresses in detail. If you're making a payment by telephone, it does have to be made a payment in full. We aren't able to specify the amounts when made on the phone, but if you're paying online or by mail or in person, you can make partial payments for those of us who are paying with quarterlies or through a payment plan. Using credit cards, either online or in person, does require a 2.5% fee for using credit cards, and that includes for debit cards as well. There is no fee for paying with a check or an e-check payment if you're paying online, and cash is only available at our branch offices. We are not able to accept cash through the mail. Electronic tax statements is something that we are able to offer, and this is something that you would get your tax bill mailed to you in an email to an email address as provided through our website. You wouldn't have to wait for the mail to be delivered to you. Instead, you would receive it immediately via an email. Additionally, you can find it on our website. You would follow our website to set up your electronic tax bill, and it is something that you would receive updates on regularly. So if that's something that might interest you, I could answer some questions about that as well. Ms. Mabel did touch on the assistance for damaged property in disaster relief areas. So in regards to these past couple of storms that we've had, you can apply for a temporary property tax exemption for the damages sustained, so long as they are at least 15% of the damaged property. The application form is available on the Harris Central Appraisal District's website, and we do advise that you include any photographs and inspections, documentation from FEMA in reference to applying for those temporary disaster exemptions. And of course, that is done through the appraisal district, as are all of our exemptions. We have a brief list here of important tax dates, and this doesn't include all the goings on that go into supplying you with your taxes every year, but this is the important ones that we like to have on and available for you. So January 31st is the last day to pay for current year taxes without penalty and interest. So all your taxes are due January 31st. We are able to set up payment plans starting in February 1st. April 1st is when collections and attorney's fees are added onto unpaid taxes for business personal properties. And July 1st is when collections and attorney's fees are added to unpaid taxes in general. So all for our residents and homesteads and non. October and November is when bills are mailed. So normally you can anticipate for your tax bills to be received during that time in October and November. They can be available online as well as through the mail. Now, what it doesn't include on here is that currently we are in the process of deciding on the rates for property taxes. So our jurisdictions are currently working on that. Keep an eye out for notices in the like the Houston Chronicle, newspapers, TV, magazines. They'll have announced when they're going to start determining those rates. So keep an eye on that to stay informed. And here is our contact information. We have our website online as well as our email should you have any questions of a more specific and personal nature that you would like to reach out to us to assist you with. And of course, our phone number if you have any direct questions and you would prefer to speak to someone over writing an entire email with your current dilemmas. But if you have any questions for me, I'll be looking through the chat here in a minute just to recap and make sure I didn't miss anything. But if you have any questions, we'll be happy to help you at any of these methods of contact. And that is it from me.
Okay, thank you very much, Shay. I know that there are a couple of questions that were in the chat, and I wanted to review a couple of those, even though I know that you guys have answered some of those. For those folks that cannot see the chat or not really paying attention to the chat, they may have similar questions that are to what someone else may have. It says here, a property tax deferral is only on the tax bill after the over 65 exemption has been calculated, meaning are you only deferring any balances due?
So let me make sure that I'm understanding the question properly. This being if the over 65 exemption is on your property and there's still a balance due, then the taxes that are due after the exemption are deferred. Meaning that if you have your over 65 exemption, you're applicable for the deferral. And say you only owe $50 a year after your exemptions have been applied to your property, those $50 can be deferred at that 5% rate, as we mentioned earlier. And it's a postponement of taxes. Those $50 are still due every year on that 5% and that 5% interest, but as opposed to the property being owed with regular penalty and interest. So you're given additional time to make those payments.
Okay.
I hope that answered
Mr.
that
Peaches,
properly.
Mr. Peaches, does that answer your question?
Yeah, I just wanted everyone to understand. Yes, I just wanted everyone to understand that the deferral is only on the balance. You have so many people who say, oh, I don't want to do that over 65 because then they're going to have to pay the big tax bill. They need to understand that the over 65 is reducing the tax bill first, and then only if there's something left, they have the option of either paying it or deferring it. So I just wanted to highlight that point so that, for some clarity, I think people get confused on what is being deferred.
Deferred. Yeah, but we get a lot of seniors that are confused on the difference between the deferral and the exemption, because sometimes they apply for exemptions thinking that they're getting a deferral, not knowing that the two are not one and the same or that they are actually different.
Correct. That's what I was just trying to highlight.
Okay, and you had another question here. Do investors benefit during the first year they acquire a property from a homestead property or an over 65 homestead property?
Right. So in that situation, I was looking at one of the slides said that the exemption that's on the property as of January 1 is what the taxing office will bill you for at the end of the year. So when an investor acquires the property, let's say in July, they're from somebody who already has an exemption in place, that exemption is going to be included in the tax bill that comes out at 2024. But 2025, you'll already have noted a change of ownership, and then that bill won't have the exemptions any longer. Is that correct?
That's correct.
Okay. Yeah, and I asked that question because I just ran into a title company that was trying to charge that homestead exemption person the full tax rate as their prorated portion from January to the date of closing, saying that the new buyer wasn't going to have that exemption. And I didn't believe that was true. I just wanted to confirm that.
One thing that could have happened is, and this is kind of confusing for everyone, that homeowner that sold the property, the seller actually can at some point during the year change their mind
Mhm.
about the exemption. So I don't think that happens that often, but it does. And
Okay,
that could be the case.
okay.
What do you mean can change their mind? Elaborate there.
Okay, so maybe they decided, in other words, they can decide to take that exemption with them. And so therefore, in other words,
Okay,
as long as it's still on the property, then the new owner benefits from it for that prorated period. But they don't have to leave it on there. They can take it with them.
okay.
So basically, if they sell this as their homestead and then they purchase another homestead, the exemption comes off the old one and then it gets applied to the new one, which means then the new buyer is now responsible for the total tax without the exemption
It
or
could.
for their
We've
prorated.
had instances where we've had to go
Yeah.
back to that homeowner and say, oh, you no longer have that immediate homestead exemption. I'm not sure if it's something the legislature thought through closely, but anyway, that can happen, right, Shay? You've seen it too.
Yeah, unfortunately, so it is something that we see. And again, it's not very often that it happens, but it can happen to where, while they did have that homestead because they lived in there on January 1st, should they move and purchase a new property and have that homestead property on the new property as opposed to the previous one that they had in January 1st, from that date forward, that's when they would have that exemption applied to the new property. And that all falls into depending on when they move and when the property is purchased.
Yeah,
I think
that
that
sounds,
question is kind of related to the question Miss Patina just had, right? So did that answer that for you, Miss Patina? Can she hear?
Um,
I
trying to get
tell you,
back.
Ms.
I'm looking for
Ganther,
the question.
can
I'm
you hear?
sorry.
Because I saw that question in the chat. Was there something else, Mr. Peachy? I think I just cut you off.
I think he had one other question. Bill, you had one about the
100%
veterans,
disabled
100% veterans exemption,
yeah,
which they could fill out form 1113. And it is available for that 100% based on the day they move in, as well as the day that their disability is established. And they simply would need the license, of course, and the VA letter to get that processed.
does it apply
now.
to mud taxes?
Does it apply to what?
Mud taxes.
I don't know.
Yeah.
I'm not
So
sure what it applies to, but
so that is a state requirement, so it does apply to med taxes as well. But what I've seen pretty frequently when it comes to this 100% disabled veterans exemptions is, folks will anticipate that it will start from the full year for when they purchase the property. So say they move in April, or they move it in January even, but they don't get the total 100% exemption from the VA until May. That exemption is only applicable to the months in which they have that exemption from when they moved in, meaning that even though they're paying taxes for the full year, only a portion of that is 100% exempt. So that first couple of months from January to April or January to May, depending on their situation, is going to still be collected at taxable value, depending on when it was. And that's just going to be something that does throw people off on occasion because they don't anticipate to pay taxes, but they didn't have it for the full year, and it becomes a prorated date.
Okay. Okay. Thank you.
Absolutely.
Okay.
I did have one other
Um,
question in the chat though.
Yes, regarding a payment plan, in the last 2 years, how long does it take the lawyers to start the process for foreclosure? So the question is, if the owner requests a payment plan in the last 2 years, how long does it take until the lawyers start the process for foreclosure? Would the owner be notified? So in this particular case, if you have a payment plan and it is active and you are making payments on taxes and there are no taxes that are owed without a payment plan being placed on them. So, and the only reason I mentioned that is because it says 2 years on here. So let's say 2022 and 2023, because those are the most recent tax years on here. If you owe taxes in 2022, you created a payment plan for 2022, and then in 2023, January, this past January 2024, you're still paying property taxes for 2022, and then 2023 becomes due by the end of January. If those 2023 taxes are delinquent, you do not set up a payment plan for 2023 taxes, you don't add them all together, then there can be litigation on the tax year that is not included in your payment plan. Meaning that if I set up for 2022, but I did not pay or complete paying, and I did not pay for 2023 taxes as of that moment, then I could be liable for, foreclosure and all that nasty business for 2023 taxes because those had not been paid and they are not under a payment agreement. So it's always best whenever you know that your taxes are going to become due to contact us and get into that payment agreement so that we can include previous years if you're still paying along with current years so that it's all applied together.
So when someone has a payment arrangement or payment deferral or payment arrangement for multiple years, are they multiple arrangements or do they all get combined together, like for one payment?
So you cannot make a payment arrangement while being on a deferral. Deferred taxes, you are given an indefinite amount of time in which to pay your taxes, and they are considered postponed. So you are still owing those taxes, but you're not required to make a certain payment at any point in time. It is at your leisure and at your ability. For payment plans, when you create a payment plan, say again for my example for 2022 and 23 taxes, I made a payment plan for 24 months in 2022. I would continue to make those payments, and then when my 2023 taxes become due at the end of January, it's my responsibility as a taxpayer to contact our office or go online, create a new payment agreement which includes our 2022 and the 2023 taxes, because while I've been steadily paying my 2022 taxes, they are not paid off yet. So until those are paid off, at the moment, we're able to include 2023 taxes in order to lump them together. So they're not two separate payments going one after another due at the end of the month. It's one solid payment for both years.
Gotcha.
Yes.
Okay.
So they're all payments together.
I saw a question in here, Ms. Lisa, that you answered in regards to ancillary probate process. Is ancillary probate process the same as probate process? What's ancillary probate?
If you have property in another state, you live in Texas, Texas is where your permanent residence, but you have property, say, in Oklahoma, what you would have to do is once you probated the will and once the will was accepted for probate in a Texas court, you would need to do an ancillary probate in Oklahoma to transfer that property to whoever the heir is. I don't know a lot about it because it would be based on the other state's law. When I've dealt with it, I always passed it on to an attorney licensed in that state. But that's what the process is. You don't need two different wills.
So your will that you make for the state of Texas or in the state of Texas, you can include property that you have in Oklahoma in that same will?
Correct.
Okay. Okay, that's good. I'm trying to go back and see if I could see all of the questions that were there. I believe that's all of them.
Someone
Were there
asked me
any
a
other questions?
question at the beginning that I wanted to talk about a little bit. Their
Okay.
question was if they're using an affidavit of heirship to transfer property, can some of the heirs give their property to somebody else? And the answer is yes. I did this all the time when I was at Earl Carl, where a family had agreed that the children living in the house, the adult children living in the house could inherit the house. So we would do an affidavit of heirship to deed the property to everybody alive, all the siblings, and then the siblings who didn't want to own that house would sign deeds giving their share of the property to the people who did want to own the house.
Okay.
I had a question. This is pertaining about that
Because-
affidavit, Lisa.
Mm-hmm.
So I think I've sent you a message. So I have a client, they got a house, the parents didn't have a death certificate. So we do an affidavit and one of the heirs is under 13.
Oh, I
And-
saw that question.
So I was told, so I Googled, I was told that we need guardianship, which her mother is her guardian. Her mother's still living, but her daddy got killed and he was the one that was the heir. So it goes to her. But then now I need someone, an attorney to fill out paperwork because she's under the age of 18. How much she cannot get her money and it has to be put into a trust or something.
Trust.
That is correct, but I don't know why her mother couldn't handle it on behalf of her. Since her
No,
mother,
they
and
said-
actually did some research. I looked up in the probate code to see if I could find an answer, and they didn't have anything about that. I would see what the title company requires because they're the ultimate.
Title company they said I needed to get an attorney. I called several title companies. They told me we need to get an attorney. Attorney has to get with the mother and then we have to have a contract on the house and get the paperwork and then he goes to the judge and get all of that information.
Because I
Yeah,
would
the
hate
title
for
company
her-
don't want to have anything to do with anything that has to do with the probate. Title company don't want to do. They don't want to deal with that.
Yeah, the
They just
title
need to
company-
get their
yeah.
legal documents or whatever's been
All
filed.
they wanted, because I already got somebody to do all the affidavit of heirship, okay, which is an attorney office. And then they found out that the child was under age of 13. They contacted the mother. She is the guardian. And then that's when he said, you're gonna have to get an attorney. And they don't do that. And he didn't know an attorney that actually does the
I
paperwork.
would. Is this here in Houston?
Yes,
Call the Houston Lawyer Referral Service.
I did. Nobody knew. I didn't call probably 15 different attorneys. I got one right now that probably gonna try to help me. One of my friends is the president of HRBC, the Houston Black Realtors,
Mhm.
and she gave me a guy, and he kind of walked me through what I kind of need to do. But he don't do it. But I got another attorney that actually said he can help file the paperwork.
Okay, because I would hate a guardianship is a really expensive process. The mother would have to have court approval every single year till the child turns 18. And I'd hate for her to have to get involved with that. One thing, this is a different situation, but I was involved with a case where the father left his insurance policy to a child, probably 13 years old. And what we did is we petitioned the court to allow the mother to put the money in a trust for the benefit of the child. And that would be the least complicated, least expensive option.
So that's exactly what I'm looking for.
Yeah, you want to petition the court you want to talk to somebody who has experience with guardianship, but you can petition the court. It's been quite a number of years since I did this, but they petitioned the court to have it in a certain amount in a trust so that they could use it for the child's benefit.
That's what I've been calling around and some attorneys say they do. Then when we tell them, then they be like, oh, I don't do that one. All right,
Can I
Oh,
ask
that's what
Patina a question?
sure.
So Patina, this child is a mother, the biological mother, or from a previous situation?
No, her biological mother she lived with her biological mother. What it was her dad, the child's dad.
Right.
It was his grandmother that passed, but he got killed. So it goes to her, the 13-year-old.
So I would imagine somebody would
Mm.
have to do a probate for him,
Okay.
for
I'm
his
understanding
estate,
now.
to show that the property would then go to the daughter. But
But-
otherwise, I couldn't imagine that they would allow the mother to do that when his estate hasn't been probated.
Well, so,
Yeah.
well, it don't have to, that's what the attorney said that he would, see, it's 13, it was 13 siblings.
Mhm.
Only 3 are living, but the ones that are deceased has heirs that's left. And that's
Oh,
where,
that's a big mess.
yeah,
Yeah.
so it But let me tell you, we got everybody agreed. So this one lady, one of the family members, she have got everybody to agree. It's just that the affidavits are done by an attorney office, and we just got to get somebody to do the 13-year-old, and we'll be finished. Once we get somebody to go to the court and be able to go to judge and get that, and then set up a trust for that child. That's all I'm looking for, and we'll be clear to close, because the affidavits are done. And they actually just told us the child is under 13 and it has to be guardianship. Because at first they was like it had to be an outside guardian, but the girl mother is still living.
Yeah, but I don't
Yeah.
think they'll be able to do anything without probating his estate first, or doing something in the court for his that shows that anything of his is supposed to be inherited
That's
by his
true.
child.
Well, they got the death certificate, and we actually has his obituary. And so I got all of that, and I'll give that now to this one attorney that he said he could try to do it. But I was just asking if
Yeah, I would see
Lisa,
if they could get a court order allowing the child share to go directly into a trust without
right,
having to do the guardianship, because the guardianship is very expensive and it's a
very
complicated
expensive,
process.
like $45,000, and nobody have it. And this attorney that I'm actually talking to, he was like, no, all you gotta do is just do paperwork, as long as you got the death certificate of the father, and we had the obituary showing that he died and got killed, and that he actually they listed the child. And the mother says she has her child's birth certificate where he signed.
But Nia is correct that they might need to do a probate of the father, just so that there's a court order stating that that child is the only heir.
They already pulled it up and made sure that she was the only heir. The attorney office already pulled it up that she was the only heir.
But there's nothing been probated on behalf of his estate that says that.
No, not probated. No probated, because
Yeah, because he died without a will. Some kind of paperwork needs to say that she legally is his heir.
Yeah, there needs to be, it's basically the procedure would be determination of heirship.
well, they told us to do an affidavit of heirship for her.
No, determination of heirship. That's
It's an
not the
actual
same as
court
the
proceeding
affidavit.
where you go in front of the judge.
Well, that's what the attorney is gonna do. Supposed to do. He the only one that I found that said they could do it. Everybody else keeps saying they didn't know what to do. They'll say they do, and then we found out they don't. So, but
That's frustrating.
I was just asking Lisa, since she was talking about the affidavits, that she might know.
No,
But
I like I said, it is quite likely that the court's going to require a heirship proceeding for the father, and then an attorney can file a petition with the court to have the child's money go directly to a trust. Because I don't want her to have to go through a guardianship. That's so expensive.
right,
and
that's
lengthy.
exactly what he said. That's what he said, that what you just said that we could do.
Okay.
This is the importance of these types of conversations, to make sure that this kind of stuff is taken care of long before someone actually passes. And for years and years and years we've been talking about this, and every month we have these sessions, there's another story of why it's most important to get this kind of thing done. Another
Yeah.
prime example.
The lesson here is, please, everybody have a will.
Yeah.
I believe there's a will
At the
scheduled
very
in
least, a
September.
transfer on death deed for your property.
Because this is a hot mess and it didn't need to be.
Yes. Mr. Petrie, was there another question that you had?
No, I think that handles it. And we just had this conversation at our national convention in New Orleans last week. So we are, and there's a bill in Congress that a congressperson has presented to try and start addressing this as well. So we are working on it to try and make it easier and better.
Yeah, I know Federal Home Loan Bank has now been giving out a lot of grants and funding to different organizations to help with airship issues and title clearing and things of that nature as well.
Yeah.
And I also see where the affordable housing conversation is heating up for our next legislative session in Texas. So I hope that we have folks really working hard on that.
I really hope so. We need
Affordable,
to.
Affordable according to whom? That's
Yeah.
the
Well,
definition.
that's why
That's the
people need to
question.
be in there. Yeah, or yeah, exactly. Yeah, yeah.
Mm-hmm. All right. Well,
Yeah.
thank you guys very much. Let's see, Miss. I have a question from someone else trying to. Okay, what was that question, Miss Bettina? I'm sorry, I couldn't read that fast enough.
That was from Melville, that I
Oh,
had a client that purchased a house last year in May, and he tried to homestead it, and they told him he couldn't homestead. He had to wait to January of this year.
And I think that most likely that was because the previous owner had taken the exemption
exemption with them
away, so he
to the
wasn't
new place.
available for he wasn't eligible for the immediate.
Okay, for the whole year, they have it for the whole year.
Right, because typically prior to the immediate homestead, you had to wait until the following January to become eligible. So it just reverts back to that.
Oh, okay, because I thought since they had said that they changed the
So,
procedure.
so Mabel,
Yes.
if Patina's buyer files this year as a late homestead application, but shows the date of purchase as the date they took occupancy, how would that be handled at the appraisal district?
So process wise, I'm not sure, and regrettably, I don't have an exemptions person on the phone with me on the call with me today.
Yeah.
But
But you see what I'm saying? You see what I'm
Mhm.
saying?
But you
Because
just
it's a late filing of the homestead exemption, it should be able to go back to the date that he acquired it.
It exactly, if in fact the previous homeowner doesn't change anything, or I don't know if they can change their minds more than one time.
Think about it this way. Even if the previous homeowner took their exemption and moved it, right? Then either last year he would have gotten their exemption on his tax bill because it was based off of what the tax bill was as January 1. All right. And if the seller took their exemption with them to their new property, now that exemption got removed on the appraisal district. So now you're talking about him being eligible from the date of ownership to the balance of the year as a late filing for his homestead exemption.
That's what I was thinking. That's exactly what I thought too, because
Yeah.
they said that
Go
they
ahead
had
and try it that way, Patina.
Huh?
Have him refile it as a late exemption instead of trying to, he'd wanted to do it then, but first make sure that he didn't already get it for
He
the
did.
full year. Okay, so there was no exemption on the property on his tax bill.
No.
Okay.
And I actually, because they Hispanic and they don't understand, so I actually do go and help them with their paperwork and did it. And then we called, he called and was on, I was there at the house, and they was like, no. And I was like, well, I thought y'all just changed it that
but
Why don't you send me,
but what does the HUD statement say when they closed
yeah,
though? Was it prorated when they
Yes,
did the closing?
it was prorated.
So it was prorated with or without the exemption.
So no, so the previous owner got prorated until May. Okay. And then my client took
with
over.
the exemption.
Yes.
with the
Okay. Then my client took over the prorated taxes from May to January. I mean to December. So he should have got homesteaded from May to December, which they wouldn't give it to him.
Right.
They told him no, he had to wait to this year of January. And we did go ahead and file. We had filed both papers. I filed it. And then they sent it back. They sent him a letter back and said, no, he can't get homestead. And then we went ahead and filed it this year for homesteaded. And he's getting it for this year. They sent it back and said it was okay starting this year.
So when did he?
So even if it was prorated at the title company with the exemption, then the exemption still should have been there for the entire year in the previous owner's name, though, correct?
It were in the previous owner's name, but it should have been taken off because the previous owners don't own the house after May 1st.
So Miss Ganser, can I give you my phone number and we'll talk offline and see how that all unfolded? Because it could be At this point, it could be for any number of reasons. We'll chase it down. How about that?
Okay, what's your number?
713
Mm-hmm.
957 5606. And I'll
957.
957 5606.
Okay, repeat it again. I want to make sure I have it.
713 957 5606.
Got it. Okay, that's it.
And I will get with the exemptions department and we'll figure out how this all came down.
Okay, I appreciate it.
So sure.
So August the 28th, we will be in person. Are we at the Sunnyside? Is it Sunnyside Multi-Service Center? Or back at the church, Miss, because I don't have the calendar in front of me. Hold on, let me see.
I think Rachel was going to try to get Sunnyside, but I
Yep,
don't know if that's been confirmed yet.
We will be in person at the Sunnyside Multi-Service Centers for the property tax and exemptions workshop. It will be hybrid, but we'll be there in person as well as on Zoom. So if anybody's available and you have more detailed questions that you want to ask, please feel free to come by the workshop that's scheduled at the Sunnyside Multi-Service Center on August the 28th at 1 p.m. So we will be there in person. Okay. All right. Well, I don't want to keep you guys any longer than what we need to. We appreciate you guys taking the time out this afternoon to present this information for today and for you guys chiming in and being interactive with us and asking questions and answering things that people may also have questions too. So thank y'all very much. We appreciate you guys continuing to tune in and to come back and continue to watch us and tell more people about us. So the more information we can get out there to people, the better.
And every month it's different. We always get a lot of great questions and different ones each month.
Indeed. Thank you, Miss Williams. We appreciate you. iPad Walmart, thank you very much. Miss Diana, thank you very much. So Shay, Miss Mabel, Lisa, thank y'all for coming out this afternoon. We will see you all next time. Miss Lisa will be back on Tuesday to talk about pro se representation, which means representing yourself when you go to court. So maybe Miss Patina, your family might be able to tune in, or your client's family might be able to tune in and kind of hear where they go for different forms and services and things like that are available for somebody that's interested in representing themselves in court and what that process is like. So we'll be back online on Tuesday, the 13th at 1 p.m. for that.
Hope to see some of you there.
All right. Well, we'll see you all next time. You all stay safe, take care of yourselves, and hopefully see you at the next presentation.
Thank you all so much.
All right.
Thank you.
Thank you all.
Have a good evening.
All right.
Have a good night.